Right now on Law&Crime Report, breaking overnight, previously sealed documents detailing Jeffrey Epstein's alleged crimes and former girlfriend Ghislaine Maxwell's involvement made public. What we're learning from the bombshell documents and about the alleged traffic ring Maxwell and Epstein ran coming up. Plus, deliberations are underway in the wrongful death case filed by the parents of Susan Cox-Powell nearly 11 years after her tragic disappearance. Will the jury deliver the justice long sought by the family?
Unfortunately, the only way that we can render justice in a situation like this is through the awarding of money.
And later, President Trump meets with the family of slain Army Specialist Vanessa Guillen in an emotional meeting. The president backs the congressional bill named in Guillen's honor.
It hit me very hard. I saw what happened to your daughter, Vanessa.
This is the Law&Crime Report, diving into true crime and all the legal stories making headlines. It's Friday, July 31st, 2020. And thanks so much for joining us on this Friday. We have a lot to get to on today's Law&Crime Report. And of course, we are going to start with that big news out of New York City. Late last night, about 10 p.m., we got a big document dump, nearly 7 pages of documents in the Ghislaine Maxwell trial, documents her team had been fighting to keep secret. Now, these documents date back to a 2015 deposition in a case that had been filed by one of Epstein's accusers, Virginia Giuffre. And what we are seeing in these documents is depositions from 2016 rather, as well as emails that had not been seen before. There is a lot to get to, and I want to bring in Law&Crime's own Aaron Keller to walk us through it. He has been up all night parsing through these 700 pages. Aaron, thanks so much for joining us on the show this afternoon.
Good to be here, Stacey. It's been a long night that blurred into the morning trying to get a handle on what's in these documents that have been released.
Yeah, and I know that there are a lot of different points, a lot of sort of little nuggets in here, but let me just start with a question, Aaron. Are there any major bombshells coming out of these documents? Anything that really surprised you, or is this a lot of stuff that we already knew about the allegations and the case?
Much of it, Stacey, is information we knew previously, but we're seeing it in a more official form than through media interviews and reports. So it carries a little bit more weight when it has a court stamp on it and when it's said in a deposition where penalties attach. One of the most interesting parts of this that's been released in this new tranche of documents were 4 pages of emails back and forth between Ghislaine Maxwell and Jeffrey Epstein himself. And those documents dated 2015 appear to read like a let's get our stories straight set of information on how to respond to accusations. So that's interesting. And it's especially interesting because Ghislaine Maxwell said when she was arrested recently that she hadn't talked to Jeffrey Epstein in about a decade. Well, those documents are only 5 years old.
Yeah, I mean, that's right. We know she had claimed she had no contact with Epstein in a decade, but clearly these emails undermine that claim. What does that do for her case overall? I mean, clearly it shows she's not been completely truthful.
Well, it raises a lot of questions, and we're going to have to see exactly how the criminal judge might deal with it if it comes to that. In the court of public opinion, it's certainly a slam against her. I'd have to go back and look at the exact terminology she used during the recent hearing in the criminal case. It doesn't look good, but could it be explained away by saying, well, I thought it was about 10 years ago, maybe it was 5, it was some point in the distant past. She may be able to try to explain it away. It's a matter of perspective and interpretation. She could be hit back with it, though, of course, if a prosecutor really wanted to dig into her.
Right. Well, let's talk about another big name mentioned in this. There are a few names, a lot of names we already knew. Prince Andrew, Alan Dershowitz, and of course, Bill Clinton. But I think one thing that is new here is that Bill Clinton has said again and again through his representatives he had never been on Epstein's private island. But as you see up on the screen during the deposition, Virginia Giuffre said Bill Clinton was on Epstein's private plane going to the island. I'm going to read it to you. The attorney said, when you say you asked him, why is Bill Clinton here? Where was here? She says, on the island. When you were present with Jeffrey Epstein and Bill Clinton on the island, who else was there? And she says, Ghislaine, Emmy, and there was 2 young girls that I could identify. I never really knew them well anyway. It was just 2 girls from New York. So from that, we can't infer too much, but what is your take on it in terms of former President Bill Clinton's involvement in all of this, Aaron?
Again, here this is turning he said, she said. If we believe the depositions from the accuser here, then Bill Clinton was there. The bottom line, though, is that even if you believe he was there, there's no direct evidence that he was involved in any alleged sex act whatsoever. The information released yesterday just indicates, well, that the accuser says he was present, and then it leads to suppositions about exactly why he may have been present. He says he wasn't. Was he there? Was he not there? It depends on who you want to believe. And even if you, again, believe the accuser, it doesn't directly tie Bill Clinton into any sex act. It just says he was there, and that's all.
And I know you had to dig deep to even find his name, right? Because you wrote in your articles on lawandcrime.com, very comprehensive, that in order to find references, not just to Clinton, but also to President Trump, you really had to go through and look for those. As for President Trump, he was really only mentioned as being the owner of Mar-a-Lago, right?
Exactly. So this document dump came down in 47 separate court documents. So to look at them all, here's what we did starting at 10 o'clock last night on lawandcrime.com. We downloaded each and every one of those 47 documents, and then I merged them all together in one master document. It's more than 600 pages long. It's been up on lawandcrime.com since last night. We got it up about an hour after it dropped. You can read through the whole thing. But here's the thing. Some of the PDF documents are actual text documents, so you can search through them. So obviously, the first tactic I took was to try to search for keywords. Some of the documents, however, are just scanned images, and they don't respond to a text search. So for those parts of the document, we had to go through page by page and line by line to see exactly whose name existed in those documents. And that was the most time-consuming part of this process. The references to President Trump and the one reference I found thus far, the one reference I found thus far to President Trump, and then the several references to President Clinton required that line by line read through scanned documents that did not respond to any search. So this is a painstaking process to go through all of it. We were up until about 2:30 in the morning. We're back up at it first thing this morning with the aid of plenty of coffee, and we're continuing to pour through those documents for you.
Aaron, I know you have a lot more work to do, but before I let you go, let's quickly talk about Alan Dershowitz's role in all this. Obviously, his name has been in documents, in accusations about this case from the very beginning. In the deposition, Virginia Giuffre alleged multiple times that she was forced to have sex with him. But interestingly, Alan Dershowitz is out this morning on Twitter and elsewhere saying he's exonerated by these documents. Help us make sense of that.
So that's his claim. He's trying to defend himself as he has all along in this case. He has said steadfastly and with frequency that he did absolutely nothing wrong here. So he's basically saying the same thing Bill Clinton said. I associated with these people, but I didn't know that they were up to anything wrong, and I didn't do anything wrong myself. That's what Dershowitz is saying, and he's repeating that claim again this morning on Twitter. What's interesting is that he's also tried to take the stance that he somehow helped to get these documents released to the public, which is interesting because legally he has opposed the release of the documents. Now that the documents are out, he's turned around and said, well, these documents actually support me because there's nothing bombastic in them beyond what we knew before. In other words, nothing new here, folks. And trust me when I have tried to refute everything that has been said about me in the past. So that's his stance on things right now. But again, if you listen to the accuser, the underlying accusations are still contained in this new tranche of documents that was released last night.
I want to mention just one more detail that I noticed and that's making a lot of headlines because perhaps it's one of the more salacious ones out there, Aaron, and that is that Virginia Giuffre testified in these depositions that she saw Ghislaine involved in sex acts many times with other women on Jeffrey Epstein's properties. And I wonder if just from a personal perspective, if that's one of the reasons, in addition to many, that she wanted these documents sealed up. What are your thoughts on that?
It could be. It's hard to look inside the mind of someone who's currently sitting in a prison cell awaiting trial on serious federal sex crimes charges. Look, that could be. The bottom line is her attorneys went through a lot of work to try to keep these documents sealed. And remember, again, Stacey, one more thing about this. more documents are set to be unsealed as late as Monday. So this is one document dump, if we can call it that. There's more that are in the queue to be unsealed. And that's assuming that the Second Circuit Court of Appeals doesn't come in and to try to prevent those additional documents from being opened up.
Well, Aaron, we know you will stay on top of all of it for us. We appreciate your hard work thus far digging in, and I know you have a lot more work to do today, and as you said, on Monday, when we expect to see even more documents. So thanks so much for being with us on the Law&Crime Report. We're going to be right back with much more on this document dump, as Aaron called it, because there are a lot more details we have not yet gotten to. Stay with us. And welcome back to the Law&Crime Report. Lots more to talk about that late night document dump in Ghislaine Maxwell's federal case. As we were just talking about with Aaron Keller, there are a lot of details in there, a lot of them that we already knew, but some new nuggets as well. I want to bring in my two guests who will be with for the rest of the show. I have Leslie Richard Chambers, who's joining us from Baton Rouge, Louisiana today. She's a former prosecutor and trial attorney, and Judge Ashley Willcott, a trial attorney and juvenile court judge. Ladies, thanks so much for being here to help parse through this detailed story with us, as well as the other big topics we have today.
For having us.
So let's first talk about the release of these documents in general. I mean, this was our lead story last Friday, that Ghislaine's attorneys were fighting hard to keep these documents sealed. They date back to a 2016 deposition that was filed, that was taken during a 2015 defamation case filed by one of Epstein's alleged victims, Virginia Giuffre. As I said, Epstein's attorneys had been making motion after motion to keep things under seal, but obviously the judge released them. And I want to read what she said, because she seemed none too happy with Maxwell's attorneys in how they dealt with their 11th hour request. Let's put up her statement now and what she said. She said that she admonished Maxwell's attorneys for filing an 11th hour request for reconsideration. And she said that the court is troubled but not surprised that Miss Maxwell has yet again sought to muddy the waters as the clock ticks closer to midnight. So Judge Willcott, let me start with you. I mean, what do you make of Judge Preska's statement here? I mean, as I said, clearly none too happy, and really admonishing Maxwell's team for the way they have handled their requests in dealing with these documents.
Sure, absolutely. So in a perfect world, every court wants to see things done timely. And so it's too little too late. When you come in at the 11th hour more than once to make these arguments, a court understandably gets frustrated, right? Because they want the opportunity for all of the parties to be heard, for all the issues to be raised. But there's no reason really that it has to be done at the 11th hour every single time. Once in a while, does that happen? It's the nature of the beast, as you know, when we litigate? Absolutely. But does it have to happen every time? No. And I just want to, Stacey, kind of go backwards and say the whole reason that parties want to keep documents such as these quiet, right, is because there are salacious details that everybody wants to know that are in these documents, but also as a bigger item, they want to make sure that the personal identifiable information or information about non-parties is not disclosed, because they do want to protect that information. But that's why a court can say it can be released, but redact that information.
Yeah, Leslie, I want to get your thoughts on this, because at one point it sort of seemed like Maxwell's team was throwing anything they could at the wall to try to get the judge to keep these documents under seal. Do you agree?
I do. And, oftentimes when you have attorneys that sort of throw spaghetti at the walls, right, they're trying really hard to find something to make something stick, to really distract from the primary issues. And, it's a tactic that I've seen so many times play out in court with opposing counsel. And, oftentimes when the opposing counsel knows that they don't have enough supporting information or evidence, if you will, to unsubstantiate the claims of either the prosecutor or the plaintiffs, you tend to see these tactics happen. And I'm pretty sure that the judge on our panel today can also attest to that. And, I really hope that at some point that the attorneys really finally get their things together, get their stuff together, because it looks like this is something that they have routinely done in practice, waiting until the last minute, sort of seemingly filed, maybe frivolous or just unsubstantiated motions, particularly when there has probably been enough time between the date of the filing and the previous court date for them to put their house in order, I guess. And so I really hope that at some point that these lawyers really get their things together and make sure that they put forth a proper defense for Ms. Maxwell, if that's what their intent is.
Yeah, I mean, to quote some of, how Aaron Keller recapped this, he noted that the Maxwell's team filed a blizzard of documents Wednesday night into Thursday morning. They had even asked for a telephone conference with Prescott. They filed hundreds of pages with the appeals court, but again, it was all in vain. So now these documents have been made public, and we're expecting to see even more documents on Monday. So let's go back to some of the things that we're learning. And one interesting nugget that our reporters uncovered is that Virginia Juvie alleges that back in 2011, actually, she first notified the FBI. Let's show an excerpt from her deposition transcript. The attorney asked, "Did the photograph ever leave your possession for a while?" She's referring to the photograph, now seen around the world, of her with Prince Andrew. She says, "I gave it to the FBI." Okay, when did you get it back? When they took copies of it? When was that? 2011, when they came to interview you? Yes. So from 2011, basically, so she had it from 2011 on, but before then, the FBI had already seen this photograph. What can we infer from that? Because as we know, Jeffrey Epstein was not charged until recently. Ghislaine Maxwell only taken into custody last month. So what does this tell us, Judge Willcott?
I don't know what it tells us. It means that there's evidence out there that information was had but wasn't acted on. And I can't answer why that happened. I don't know in the mind of law enforcement or those who have been involved in this. But I am going to say this: the more information that comes out, the more documents, as Aaron mentioned, are going to be released and reviewed, the more specific details are going to come out that make it clear that there's a whole lot more to this story in this big picture than we know or have heard. And I believe that other people were aware of, but nothing had happened at the time. It's almost like it was ignored. And I hate to suggest it, but you do wonder if it's because there were people in power with financial means that it was just kind of ignored as to the allegations and that something might have been going on.
Let's go back to what we were discussing with Aaron, which is the role of former President Bill Clinton in all of this. We know that Bill Clinton has admitted that he was on Jeffrey Epstein's private plane on 4 different occasions. But in the deposition with Jeffrey taken back in 2016, she says that he was also on Jeffrey Epstein's private island when there were young girls present, an island where she says orgies were happening everywhere, an island where she says she saw Ghislaine Maxwell engaging in orgies with other young women. And Aaron raised a good point that it's a case of he said versus she said, because the Clinton team will continue to deny that the former president was on Epstein's island. But Leslie, what is your take? Is this any more incriminating than what we had seen before for the former president?
I think it could be, considering what we know about President Clinton's history and his involvement with affairs in his own administration. I think what's unfortunate here, too, is that former President Clinton was even associated with someone like Epstein, particularly when it sounds like a lot of people had common knowledge of what was going on that island. And I don't want to sound accusatory towards the former president and say, you had to have known what was going on. I think that it is overwhelming to have a former president with the access that he has, the Rolodex, if you will, that he has, and knowing usually most of our politicians know backstories of people, right? I just hope that he is truthful when he says that he had no idea that these sorts of things were going on the island and that he did not participate in them. However, I do believe that in the view of public opinion, that might be hard to believe.
Well, we will wait and see what more will be released on Monday. All other names mentioned in the documents out so far in terms of who Virginia Giuffre recalls seeing on Epstein's island were Al Gore, Naomi Campbell, and Heidi Klum. I'm sorry, not on his island, but rather his private jet, which she said was nicknamed the Lolita Express. Again, if you want to read the documents yourself, head over to lawandcrime.com, where we have all nearly 700 pages of them uploaded to our site. We'll be back with much more right after this. And welcome back. Let's talk about Vanessa Guillen. She is the young Army specialist, just 20 years old, from Houston, Texas, who was bludgeoned to death with a hammer in the armory room at Fort Hood Army Base where she worked. This happened back in April. Her family says she was getting ready to file a sexual harassment report against her alleged killer, who was a fellow soldier at Fort Hood. That soldier, also 20 years old, Specialist Aaron David Robinson, he in her disappearance, killed himself after he was confronted by police in Killeen, Texas, earlier this month. Well, yesterday, the family of Vanessa Guillen was invited to the White House to meet with President Trump and talk about the bill they are pushing. The bill is being called #IamVanessaGuillen, and it is, of course, named in honor of Vanessa. It would allow active duty service members to report sexual harassment or assault to a third party outside their chain of command. The idea behind this to eliminate fears of retaliation that often discourage soldiers from reporting sexual abuse by superiors. Let's take a listen now to that meeting in the White House between the president and Vanessa Guillen's family.
What we could do collectively to get justice for Vanessa is we need reform. We need a bill. And, you know, I drafted a bill that #IamVanessaGuillen. Mark Rain Mullen from Oklahoma.
Good guy.
Great guy. Love him. It's right now in Ledge Council. But what it does is it says the way we have the EEOC, which is the Equal Employment Opportunity Commission, how if someone can report something, you go to the EEOC. We're looking for something that's going to allow our military, our soldiers, to have the same rights and protections. So that way they're not going to their chain of command or internally. What they're doing is they're going outside the command and reporting something. So suppose this kind of situation would have been in place, if we had this kind of bill in place, Vanessa could have reported this, and they would have said, wait a second, this guy Aaron Robinson has a few of these problems. Like, look at this guy's...
Did she report anything at all?
She reported it to her family and friends and some of the soldiers. She didn't do a formal report.
Not to the fort, not to the people.
Right, not to the command, her bosses, who are also above her, who she's saying that were sexually harassing her.
So we're going to look into it very powerfully, and we already have started, as you know.
Right.
And we'll get to the bottom of it. And maybe things can come out that will help other people in a situation like Vanessa.
Well, earlier speaking in the clip, that was the family's attorney, Natalie Kawam, who was speaking about the bill, which she helped draft. Let me bring back my guests. I have Leslie Ricard Chambers, a former prosecutor and trial attorney, and Judge Ashley Willcott, who is a trial attorney as well as a juvenile court judge. So, Leslie, let me start with you. I mean, this bill, it seems like a no-brainer, and it's something that has been talked about for years and years. I mean, we know there has been this ongoing problem of sexual abuse within the military and fear of reporting the abuse because of how the chain of command works in the military. Leslie, what do you think the president's voicing support in this meeting does to bolster the chances of the bill?
Well, his voice of support is very vital in pursuing this legislation and making sure that the issue gets addressed. What often happens in situations like this is that you get a task force created, right? And that task force that conducts a review of a long list of incidences such as this, and they go through a process where they determine whether or not there's a breakdown or a flaw somewhere in the process. And also, you have to consider the fact that this is a young woman. She's 20 years old, and she was obviously subjected to some sexual harassment, and she felt that she could not go to her superiors, which she should have felt that she could do. Unfortunately, she did not feel as though she could. And so you have her killer who decided to take the incident into his own hands and kill this young woman, unfortunately. And so, with the president's backing, I think that we can see a lot of support from both both houses of Congress to say, look, there needs to be this issue needs to be addressed. And we need to make sure that not only is it addressed at Fort Hood, but we need to make sure that it's being addressed at other Army bases, military bases across the country, because this is what our military is supposed to stand for. It's supposed to stand for freedom. And the foundation of that freedom is threatened when there is not enough support of our military members and those who are pursuing a military membership at these bases.
Independent panel in Fort Hood, an independent panel rather, to review this case. But Judge Ashley, is this the same thing? I mean, why is legislation that would require an outside party to review cases like this so important versus just naming an outside panel on a case-by-case basis?
Absolutely, because it doesn't make a big enough systemic change if you do it on a case-by-case basis. And the reason is this: it doesn't make good common sense that you have to report sexual harassment to superior when superiors may be involved in it in some regard. So it makes really good sense as a system to prevent and stop sexual harassment, sexual abuse, is to have an independent party, an independent panel that you can report to. By doing it legislatively, it would happen in every case. And I'm going to say, we all know the military does things very well and the things that it does, and there's no reason I see why it shouldn't be able to set up an independent person panel review in every case in which there are allegations of sexual abuse or sexual harassment.
Well, we'll certainly be keeping our eye on what happens with this legislation as it moves through Congress. And I also want to note that during the meeting or after the meeting, President Trump offered to pay for the funeral services for Vanessa Guillen. Her parents, her mother and sister, have still not received the young soldier's remains because they were being held pending the investigation. Well, let's switch gears now and talk about another tragic case, but this one occurred nearly 11 years ago, and to this day it continues. We are talking about Susan Cox. In 2009, Susan Cox, a mom of two boys, disappeared. Her husband, Josh Powell, had allegedly been abusive and threatening. At least that's what Susan herself wrote in a letter to family and what she told friends. Now, he claimed he had taken their two young sons, who you see there in the picture, camping the night of Susan's disappearance, but it was freezing that night. As the investigation into her disappearance unfolded, nearly every sign pointed to her husband. And in 2012, as the investigation into Powell's role in his wife's disappearance continued, Powell attacked his 5- and 7-year-old boys with a hatchet, then set the Washington State house he had been living on fire with the boys inside. He killed the boys and himself. Fast forward a few years, Susan Cox's parents sued Washington State's Department of Social and Health Services, claiming that social workers did not do enough to save the boys. The suit was tossed out, then it was appealed to the federal level. Finally, in 2019, the U.S. Court of Appeals ruled that this case could go forward. It started in February, only to be delayed once again because of the coronavirus. Well, just a couple of weeks ago, the civil trial resumed. Now the jury is deliberating in the case. I want to play you some of the Cox family attorney's statements, what he had to say.
Just as we take a look here, Susan's disappearance, the boys are placed in custody, visits are moved to Josh's home. Josh murders the boys. As this process went on, the state was provided more and more and more reason to be concerned about the safety of these boys. And as it got closer to February 1 and the court's hearing, ladies and gentlemen, that risk simply exploded. The state took no action. He lost Tim Atkins. He wasn't going to get his boys back. He had to do the psychosexual. He had to do the polygraph that he was so concerned about. So we can graph what happened, ladies and gentlemen, remembering that the state's obligation, its primary obligation, is the safety of the children. And I think this pretty much tells you exactly what happened in this case. They failed to follow their own policies. They failed to follow the standard of care of the industry. You will see in the jury instructions that failing to follow a policy is evidence of negligence. Well, here it's overwhelming evidence of negligence because the policy existed to accomplish the goal of the safety of the boys, and they didn't follow it. The result was the tragedy that we are here talking about. There are a couple of instructions, ladies and gentlemen, that I want to particularly draw your attention to. Jury instruction number 13 talks about the duty. And it says, in this case, the state had a duty to exercise reasonable care for Charlie and Braden Powell when they were under its care, custody, and control. What does it say about the duty to exercise reasonable care? It extends to risks that are foreseeable. The foreseeability of the risk of harm is not limited to the actual harm suffered. They don't have to foresee that he's going to hatchet, douse, and burn his children. But rather it is determined by whether the actual harm fell within the general field of danger which should have been anticipated. In other words, the general field of danger that is identified in the state's own policies.
Well, that was the Cox family attorney, Ted Buck, during closing arguments, saying that it was the state's obligation to exercise reasonable care in this case. They didn't have to foresee that Josh Powell was going to hatchet his children and burn the house down with them, but they should have had reasonable care. They should have listened to warnings from the Powells that this man was not fit to care for these children. I want to just add one more detail to this case, which is on the day when Josh killed his children and himself, a social worker had dropped the kids off for a visit. Josh Powell slammed the door on the visitation supervisor and then essentially locked her out before attacking the boys with a hatchet and setting the home on fire. Judge Ashley, let me start with you. What is your take? The jury is deliberating. It's hard to know which way they will go, but do you believe, based on what we know about this case, that the State Department of Social and Health Services was negligent when it came to protecting these boys?
So let me first say a horrible case, and there is no amount of protection anyone can offer a court, the agency, to prevent children from being harmed by those who are evil, which is what I would call this father. Having said that, if you look at the definition that we just witnessed him saying in his closing argument, for negligence and failure to follow policy in that state is negligence, as well as failure to meet the standard of care, I believe, based on what I know, that there are good grounds that show this agency was negligent in this particular case. Of course, that's for the jury to decide, but I do believe there's been evidence of that in this case.
Let's go back to the Cox family's attorney and listen to a little bit more of his closing statement.
At 12:15, the first 911 call ends. We know at this point the boys have been doused in gasoline, but there's no fire. What's going on? At 12:24, Elizabeth Griffin Hall makes the second 911 call. The house has just caught on fire. We know the boys are still alive because they died of carbon monoxide poisoning with soot in their windpipes. It's 21 minutes and 44 seconds. If Elizabeth Griffin Hall is accurate in her estimates. We know that they were conscious for some time because, ladies and gentlemen, they swallowed gasoline. It was in their gastric content. It was in their blood. It made its way all the way to the vitreous of the eyeball. The forensic experts all agreed you can't swallow when you're unconscious. Now, Dr. Nelson, the state's expert, said, well, it must have gotten in some other way because it wasn't in the urine. But ladies and gentlemen, if you look at the toxicology reports, what will you find? The urine was never tested for alcohol. Dr. Nelson is flat wrong. I suggest you pay attention to the actual ME who did the autopsy and told you most likely this got in their system by swallowing. I suggest you listen to Dr. Weck, who agrees with the ME's conclusions on it. That slow curtain, ladies and gentlemen, of consciousness, we know it overcame the voice at some point. And only you can decide when, thank God, they finally hit a level of unconsciousness where the pain went away.
Attorney Ted Buck just detailing some really horrific details about how those little boys died, saying they died of carbon monoxide poisoning. They were soot in their windpipes. They had swallowed gasoline. Let me ask you, I want to note another point here, which is that in this civil case, Susan Cox's parents are asking the court to award them $87 million in damages, saying that $87 million equals $5 million for each minute the boys suffered at the hands of their father. What do you make of that request? And if the jury does find in their favor, do you think it's realistic that they might get that amount of money?
I don't know if it's realistic, but I can tell you that it does sound punitive. And I think that, they are asking for a number that is out of the ordinary and that's beyond consciousness, because the events that took place surrounding the deaths of these poor boys is unconscionable. And so, I do believe that the jury will make some type of connection or nexus to that feeling of unconsciousness that, yes, you're asking for $87 million and maybe, that's far-fetched, but unfortunately, these children lost their lives in a very inhumane and devastating way. And so the $87 million to me seems to be more punitive, just really to illustrate the devastation of the deaths of these children, as well as how traumatic the death was, losing their mother. And then if you look at the picture of these beautiful boys, and I'm listening to the closing statement of the attorney, it sounds like these children were made to swallow gasoline. That is so horrible. I don't know that you can quantify the pain that the parents, and I'm sorry, that the family is experiencing by the deaths of these children. And so the $87 million to me is an illustration of not being able to quantify that.
Absolutely. Regardless of what happens with the verdict and the damages, by asking for that much money, they are certainly making a very stark point. $87 million, $5 million for every minute those boys suffered allegedly at the hands of their father. We're going to take a quick break. When we come back, much more to talk about in this case about Susan Cox-Powell. Stick around. We'll be right back after this. Well, we are talking about the civil case involving Susan Cox-Powell, the young mother who went missing back in some 11 years ago now, actually, in 2009. Her husband always presumed to be the main suspect in her disappearance, though her body was never found. Well, fast forward 11 years, her parents were finally allowed to bring a civil suit against Washington State Department of Social and Health Services. They claim that social workers didn't do enough to protect their grandsons who were killed by Josh Powell, Susan's husband, the boy's father, back in 2011 when he allegedly hatcheted them to death and blew up the house in which he and the boys were at that time. Truly tragic details. I want to go back to some of the trial right now, which we heard unfold in recent days. The jury right now in Washington state is actually deliberating in this case, so we could get a verdict at any moment as to how they decide on the Department of Social and Health Services culpability in the case. In the meantime, we want to go back to some of what we heard in the trial over the last few days.
This will be the only and final time that you hear from the state in this matter until we have the opportunity to talk to you after you've come back with whatever decision you're going to be making. Now, we would all recognize that we've been on a very long road together here, started back in February. And all this time, in order to address a very tragic incident, one which most of us will never forget, one that was not foreseen by the state. Now, why do I say that? And I say that because of what is occurring is what we would refer to, and you've heard throughout the trial at various stages, hindsight. Hindsight biased, armchair quarterbacking, second guessing. You've heard throughout from the very beginning in an opening statement, spinning of what the actual evidence and facts is in this case. There's no ifs, ands, or buts that it was a very tragic matter. But the state, and we're going to show you in a moment, that the state took this very serious. They did their job, they followed their policies. And what we're going to ask of you is to evaluate this case based upon the information that was known at the time, and that the state's reliance upon professional evaluators, a knowledgeable court, a judge who was overseeing these proceedings.
And that was Joseph Diaz, the attorney for the Department of Social and Health Services in Washington state, during his closing argument, saying you heard spinning about the evidence and the facts. In this case, there are no ifs, ands, or buts. It was a tragic matter, but the state took this very seriously. Judge Willcott, what will the jury be considering? I mean, because it is sort of a he says, they say in terms of how the department did handle it.
That's absolutely right. So we know the jury is the trier of fact. Exactly what they have to determine is, did DHS violate their own policy or not? Number one, did they meet the standard of care? Number two, all of the facts before them based on the evidence presented is what they have to use to answer those two very questions to decide whether or not the department was negligent in this case.
Leslie, we know that the courts ruled that the actual social workers themselves who dealt with this case could not be implicated or held responsible. So it just goes to the department. But what do you think in terms of what the jury will be considering and how they are going to really decide if it was the department's fault? I mean, certainly Josh Powell had a very checkered past. He was the key suspect in his wife's disappearance. He was undergoing a psychosexual evaluation at this time. Should they have just cut off visitations with the children, especially after the Coxes has said we don't want them around our grandson, or was it their duty to allow this visit to go forward?
Well, I think that the jury, who's made up of everyday people, they are going to be looking at whether or not the department dropped the ball in, number one, making sure that these children were safe, and number two, if they had knowledge about their father's history and his potential for violence and other things, whether or not this department did what they were supposed to do to keep these children safe. And I think that for me, just sitting here on the outside looking in the trial, if you will, to me it looks like they probably did. And whether or not you want to put it on the individuals themselves who went out to the home to conduct these investigations and then decided, well, there's nothing else that they needed to do. Or if you look at the policies related to how the department itself conducts investigations, I think that either way that the jury could find that 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 the employees as individuals dropped the ball, and the employee or the institution or the department itself definitely dropped the ball.
Well, we're going to be watching closely. Day 2 of jury deliberations underway. Be sure to stay tuned to our website, lawandcrime.com, for any developments on the verdict. That does it for us today. I want to thank you, ladies, both for joining me for this edition of the Law and Crime Report. We will see you back here next week. Stay tuned for regular programming here on Law and Crime.